Evening, everyone. I hope everybody is well. I see my watch says it is now past. So let's start. I see the light is very bad. Let me see if I do something about the light, that it's not that bad. Sorry. That's a bit better. Sorry for the late start. I'm sure wherever you are also experiencing the stage 4 load shedding. So thank you for bearing with us. I was hoping to join with my tablet, relying on the cell phone network to start the webinar on time, but unfortunately that also failed because clearly one forgets that the cellular towers also need power to have strong signals. So thank you for bearing with us. I said before we start with the presentation, there was a few emails that I received and also posts on the forum about the activity or portfolio 1, and some people that only received the last 2 activities, it would seem yesterday or the day before, and the due date is today. So I said we will just have a chat or some feedback to see if that's a general problem that everybody did not receive the last topics when I posted it last week, and that maybe we must look at sort of adjusting the submission time. I don't know if you want to maybe just type in the chat room, or I see there's a hand, Grace. Yes, Grace.
Hi, Advocate. How are you?
Fine, and you?
I'm doing good. The activities were only available on Monday. When you posted it on Friday, it was logged. I only unlocked it on Monday. So delegates only managed to receive the activities on Monday.
Thanks, Grace.
All right.
Okay. 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 So I see Zenani, your hand is also up.
Yes, I just wanted to inform you that I also only received the activities yesterday morning, actually, and not Monday. So I wanted to know if there's any possibility to postpone the due date, if that's possible.
Yeah, that's why I said we will discuss it tonight, because it seems it was a general a problem. So that's why I said we'll discuss it and agree on a new submission date. I also I see Marlene, you say you did try to submit your portfolio, but the system is showing. I don't know, Grace, if you are aware of any errors.
Yes, e-leader was down yesterday, a day before yesterday night and yesterday night, but now it's up and running. It was just for a few hours in the evening, yesterday and the day before yesterday.
Okay, so Marlene, it should, I don't know if you've tried, maybe try again to see if you can submit it now. Then I see Fendi. Yes, I agree. What I will do, I think what I was thinking with the next assignment, I'm going to release all the activities at once. So giving everybody time, or I will just also talk to Grace. It seems I did something wrong, Grace, when I posted the activities. So we will also then, depending on when we agree this portfolio 1 must be submitted, it will then also determine the submission date for the last portfolio, because there are 2 portfolios. I think the one lady that did ask for a postponement due to personal circumstances, we gave extension until the 2nd of November. So that would be Tuesday. So that would be a week for the submission from when you all got the topics this Tuesday. So it will give you a week to submit the portfolio one, can I maybe just get a quick indication, will the 2nd of November then be sufficient time?
That will be in order. Thank you so much.
Okay. It seems that there is a consensus on that. Okay. Okay, good. Okay. So yeah, so we agree that the submission of the next of the first portfolio will then be the 2nd of November. And then if I remember the schedule correctly, I then said that the next portfolio would have been due on the 22nd of November. Is that submission date then, or sorry, the 11th of November? Is that submission date then sufficient, or do you want us to move it after the 11th to give you, because that would be, if I just have a look at my calendar, if we say Tuesday is the 2nd, that's going to be a week and a half for the second portfolio, which I think might be a bit, was not going to be enough time. So Grace, can the submission date for the portfolio to be after the date on which the online course is finished? Is that possible?
Yes, it's very possible as long as they're in agreement.
Okay. So can we maybe then agree, I'm just quickly looking at my calendar here against the wall. Let's move it to the 16th. So the submission date for the second portfolio will be the 16th of November. Will that be enough time? If we can maybe just get a quick indication. Okay. Okay, good. Okay. So I think there's a majority that the second portfolio will then be in on the 16th. So Grace, if then the first portfolio is then due the 2nd of November, and the first is due on the 2nd, and the second portfolio is due on the 16th. I will then also upload the portfolio 2 activities on Monday. Grace, maybe I must just have a word with you to see what am I doing wrong. It seems I'm not releasing the activity when I'm posting it, so I'll just have a chat with you. Okay, so I see, I don't know if there's any more hands. Grace, I see your hand is still up. Okay, good. Okay, so for I know with the video, sometimes the connectivity is also a bit bad. So for now, I'm going to see how it goes. Then I will leave the video on to see the quality. So if anybody at some stage see that the quality goes down because of the video, just let me know so that I can switch off the video. Okay, so in terms of what we said before is that we will have a look tonight at the proposed rules for the Children's Court, because you'll see if you look at the Children's Act, is in any way the Act makes provision that rules be written for the court, specifically for the Children's Court, to make the procedures in the Children's Court hopefully a bit more user-friendly and a bit more specific to the Children's Court. So that was the whole idea behind the rules. Unfortunately, I did say I will try to establish the date on which it will be published. I'm just waiting still for feedback from the person from the rules board. I will try to get the date from him. I'll just follow up from him with him, and then I will post the date also. So as we are speaking tonight, the rules have been finalized, but it has not been published in the Government Gazette. But I will let you know that date as soon as I know it. So if we have a look at the rules, the summary of the rules is follows. It has 12 chapters. It has 65 rules. Annexure 1 consists of the forms, and then Annexure 2 to the rules deals with the tariffs. That's still to be developed. That is not yet part of the proposed rules. So those are a quick summary of the rules. So if we look at the chapters, the chapter 1 deals with the purpose and interpretation. So usually those are the introduction to any rules, to any act, to any regulation, deals with the purpose and interpretation of the rules. Chapter 2 deals with the general provisions. Chapter 3, I'm going to look at, but I'll also upload the PDF of the proposed rules, so you'll have all the rules. I'm not going to look at each and every rule. I'm really looking, as I said before, at the rules that are applicable to this chapters of this online course. So, for example, Chapter 3 and Rule 5 that deals with the clerk of the court. Those rules deal with the administrative duties of the clerk, how they do things, and so on. And I think that you can have a look at your own time. Chapter 4, these are the more rules that are more important rules for the purpose of this course. Deals with children's court proceedings and how investigations need to be done. Chapter 5 deals with parental rights responsibility agreements and parenting plans. Again, the rules make it just a bit more practical going from the Act. Then Chapter 6 deals with the child in need of protection and foster care. Chapter 7 deals with adoptions. Chapter 8 with inter-country adoptions. Chapter 9 with some general housekeeping rules. Chapter 11 deals with costs. That will also then link to the Annexure 2, which will contain the tariffs that you will surely be interested in. And then Chapter 12 again has some general rules. So, like I said, in terms of all legislation, acts, regulations, usually Chapter 1 rules, first rule deals with definitions. I've highlighted some definitions. So to see if they, in terms of if you compare the rules and the act and the regulations, what do they bring? The rules bring in something new, and the one is that, and it's, I think for us that is in the law, this would seem a bit, sort of clear and without any question. But remember also the rules and the children's court is a lot of times are used by lay persons. So a lot of the definitions, although we will say, oh, okay, no, that's like, common sense. One must remember the rules are also there for other people. So they say the applicant means a person who approaches. And you will see later on where this comes relevant. A comfort person means a child or has a close relationship with the child, is not necessarily a party to proceedings, and who will provide reassurance and comfort to the child during the proceedings. So you'll see later on where this whole comfort person comes in. So if you then read it in the rules and somebody will ask you, what does it mean? A comfort person is then somebody that's trusted by the child, has a relationship, is not a party to the proceedings, and who will provide reassurance and comfort. And you will see later on where this comes relevant. A comfort person will, if the court deems it necessary, can be part of proceedings. But you will see this is not necessarily a party to the proceedings. And this might lead to some kind of disputes, because I can think that maybe this comfort person that the child is near to might be somebody like a new husband or a new wife or granny or grandfather. And then the one parent is going to say, no, 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 this person should not be allowed into the proceedings. So this might be a bit controversial, but we must always remember that the children's court and the proceedings in the children's court is there for the children and not there for the adults. So the respondent means any person against whom relief is sought or who may be affected by the assistance or relief sought by the applicant, including an interested party. So if you had a look at the Act and the regulations, there's that says that also an interested party can approach a court. So that interested party can also be defined as a respondent in terms of the rules. So what is the purpose of the rules? And I think why I highlighted this was to say that, sometimes the court would want to apply a rule. One would find that, I think especially it does a lot of litigation in the magistrate courts, in the regional courts, in the high court. So are used as a I want to say, in fact, you will get the presiding officer that will nitpick and say your papers or your pleading, paragraph 1A does not comply with the rule, and therefore the matter is struck or the matter is postponed. So I thought it is important that we see why the rules are there, so that if you maybe bump into a presiding officer that wants to use the rules as a way of kicking for the sideline, if I can put it like that, you can say to that presiding officer, no, the purpose of the rules were not for you to use it to punish litigants. There is a purpose to the rules. So the rules are there to promote access to the court and to ensure that the right to have disputes resolved by application of law by a fair hearing is given effect. And then also full effect of the objects contained in Section 2 and the principles contained in Section 6 of the Act. But you remember, those are the, sorry if I can just quickly grab my Act. So you will remember those are the ones that deals with the spirit of the Act, how the court must approach matters in terms of the Children's Act. So the rules are there to also to the object of the Act. So if you quickly have a look, section, for example, to promote the preservation and strengthening of families, to give effect to a child's constitutional rights. I mean, those are the Section 2 objects of the Act, and that's the rules are also there to promote effect to the objects of the Act. So your general principles as set out in Section 6, again, this idea that the Act and then the rules they protect, promote, and fulfill the children's rights are set out in the Bill of Rights. So the rules cannot go contrary to the Act as in mind in Section 6 and Section 2. Again, to enhance the standard of best implemented in Section 7, that that chapter in the course that dealt with the whole. So the rules are also there to promote the best interest, and I think especially here, if we look at Section 7(1)(n), you will see that is the one that says that actions or decisions that must avoid or minimize further legal or administrative proceedings. So the rules are not there to make a child's life more complicated. It is there to make the child's life less complicated, and there is a swift, the dispute is dealt with swiftly. And then to ensure that all matters in court are dealt with expeditiously and prioritized as contemplated in Section 4(b) of the Act. Is that again the general principles that is set out in the Act. So the application of the rules the rules are there to, and I specifically highlighted the list of people that is mentioned in the rules to say the court, the family advocate, legal practitioner, a social worker, or other suitably qualified person with a like position, and having regard to the child's age, maturity, and stage of development as contemplated in Section 10, must give due consideration to the views expressed by the child and ensure the child's right to participate in an appropriate way. So, again, the application of the rules is there just to highlight that this is about the child, that the child must, we must give consideration to the views of the child and that ensure that the child participates. And all of those people listed in chapter 1 under application, that is on my interpretation of the rules, that is their duty to make sure that a child's views are given consideration to participate. So how would the rules be interpreted? And it goes back to the what I said at the beginning, that the rules are not there to be used as a delaying tactic or as a way for the court to not deal with matters. So the rules must be interpreted in respect to following objectives: the child's best interest, for a fair hearing and enforcement of their constitutional and other rights. So not only, I usually emphasize the child, but it's not only for the child, it's also to make sure that any other party involved will have a fair hearing, to secure a simplicity and uniformity in procedure. I think usually those are why rules are there. If you look at the rules of the regional court, rules of the high court, it tells you if you want to bring an application, do it this way, this way, and this way. Nobody can have any doubt about it. So again, even these rules have that same in mind in terms of making sure everybody knows what the process is and that it's simplified form. If you do it in Kroonstad in the Free State or you do it in Johannesburg in Gauteng, that is the process that you will follow. To provide for the care, protection, and physical and mental development. So sure, that's a lot of sort of very high ideals almost. But again, the rules are there to make sure that the child's welfare is put first and not any tactics or anything like that the court or that anybody wants to use for the rules or use the rules for. To facilitate expeditious finalization. And again, I think that speaks to point C that says that the rules are there to secure a simplified and a uniformed way of dealing with matters in the children's court. So the rules go a bit further and talks a bit more about child participation, because you will remember Section 10 of the Act only says that take into consideration the age, the maturity, the stage of development, a child can participate in an appropriate manner. So the rules now try to maybe speak to that idea of participate in an appropriate manner. How will that take place? So the rules, I think, are trying to guide the court into ensuring participation. So the rules say that the child is to be provided with an equal and inclusive opportunity to participate during the proceedings. From this and from my own experience where I act for children, is that a lot of times you are appointed at the end, almost end of a matter. So parties have been litigating for 12 months, 2 years, 3 years, and then somebody decides, oh, okay, let's appoint a legal representative for the child. And then all of a sudden, the same luxury that is afforded to the parents who have been litigating for 2 years or a year or 10 months. And, you know, that time or that opportunity is then not given to the child. So if you represent the child and the child now can, all of a sudden they want you to represent the child, present the child's case at number 99 in one day, and then everybody gets very upset if you say, no, 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 I also want an equal opportunity to participate in the proceedings. I also need time to prepare a child's case. So emphasizing to participate. And the child must be informed that this is the child's rights. Now, again, I think this can maybe lead to problems, because I'm sure in some jurisdictions, I know there is presiding officers that don't feel comfortable talking to children. So the question will be, who's going to inform this child of this right? Must the child be present during the first appearance so that the court has an opportunity? Or is the court going to say to the social worker, please tell me that you discuss this with the child, that they have a right to participate? I think it can be, although it's there, I don't know in practice how this is going to be implemented. If I have a wish, I would be that the child is being informed, will be informed by the court in an appropriate manner, because it says in an age-appropriate manner, to say to them that they can participate and get some feedback. For interesting, but just about this whole idea of child participation, in France, when there's a divorce or any kind of dispute with regards to children, there's, in terms of their procedural rules, there must be a first interview with the child in all proceedings. And then the child will be asked about views and participation. So they see it as the first step at the start of any proceedings. But I mean, we don't have that kind of specific procedural rule that says, and also that speaks to when it must happen. It says child participation, the child must be informed, but it doesn't say when and who. So it says that the process must be explained in a simple language so that the child can understand it. I think, again, that's a bit of common sense. Deal with the child in a transparent, honest, and respectful manner. Ensure in an informal, child-friendly, enabling, and safe environment. I think most courts get that right. I think, and I know in some jurisdictions, the children's court sits in a court, which I always think that if you're going to now have a child coming to court and a presiding officer explaining to the child in a simple language, in a friendly environment, your rights and how do you want to participate. I don't know, bringing a child into a formal court setting where the magistrate is sitting there at the top and everybody's here at the bottom, if that necessarily is a child-friendly and enabling environment. So again, it says take measures to promote that. So here it comes to say that either intermediary or interpreter, which I think a lot of times there's language issues, an interpreter would be an obvious choice, as well as allowing a comfort person. So going back to the definitions of what is a comfort person. And then allowing sufficient time for the hearing, taking into consideration the child's needs to rest when tired, to eat and refresh. So at the last one, G, is one would think that if the court then says, okay, the child must directly participate in proceedings, which I don't think often happens in the children's court, but if it does, they say, okay, let's not sit for 4 or 5 hours on end, take into consideration the child's age and make sure that there's enough time to rest. And also in terms of, I know a colleague of mine is busy with a matter where the child is testifying and the child is subject to waiting for a courtroom, waiting for intermediaries. So that is surely not what this has in mind. So if you know the you have to wait for a courtroom, for example, you have to wait for the criminal court to finish, that you take that into consideration, not make the child wait from like all of us in the children's until 12 o'clock, rather say 12 o'clock or 1 o'clock, and then be a bit more practical in consideration of the child's needs. Case management. So again, this is something that is happening in practice, although it is not official. I think in a lot of cases, this is what the court tries to do in any way by saying, okay, we're going to come back in 2 weeks or 3 weeks or 4 weeks time, then this and this must happen. So the rules now making it a bit more official and also saying what is the purpose of the case management. Again, I think something that in the High Court is nowadays happening a lot, this idea of a case management, matters are placed on the roll just for case management to ensure that a matter is ready, that there's no delays. So again, this idea being brought into the Children's Court through the rules. So it says the objectives of case management through judicial intervention in the interest of justice are to protect and act in the best interest of the child, to address the problems which cause delays in the finalization of cases. So the presiding officer, similar like in the High Court or the Regional Court, that he must control the conduct of proceedings and ensure that all applications and inquiries are dealt with expeditiously, so that matters can come to a point. And then what is important, that if the presiding officer will find that any party is delaying or not cooperating, cost orders can be made. Okay, it's something, I don't know, in your experience, something that the Children's Court is not always willing to do or willing to entertain is cost orders. But again, the rule says, and also that if the presiding officer finds that there is a delay or somebody is deliberately causing delays, a cost order can be made. So, and if the same presiding officer must, where reasonable possible, deal with all applications and inquiries irrespective of the matter, dealing with a specific child. So what I get from this, and I will be interested to hear what you say, is that if a presiding officer is the case manager, that presiding officer must then deal with everything with regards to that child. So not like we do get in some children's court that you start with the case management and then the presiding officer dealing with the case management also then is chopped and changed, because I think that's not the purpose of case management, because now, like in a lot of matters, every time you get a new case manager, that manager might want to put their own stamp, change direction, so that the same presiding officer must deal with the matter with regards to a specific child. So I just want to maybe stop here. I cannot always see you while I'm in the slideshow in terms of questions. So I don't know if there's any questions and comments at this stage about what we have been talking to up to now. Yes, Ali, Ms. Liebenberg, I agree. I think that will be, if you look at a lot of times in what happens now in the High Court, if case manager approved or appointed, that judge will take the matter through to a certain point. In terms of, usually they take it up to when it's ready for hearing, and then the matter will be placed. So I think that's the only way of case management. Okay, so I see somebody says that the video, we can switch off the video. I don't have a problem with that. Then you can also you don't see my dogs getting on and off my chair. So that will also be better. Any other comments up to now? Yeah, I should have apologized if my voice disappears. Sorry, I apologize. I have been in bed for with a chest infection. So if my voice disappears, apologies for that. Okay. So it will seem that, yes, Anani, the matter is recorded, and as far as Grace, usually it is uploaded on the web page. So yes, it is available. Okay. I don't see any hands. Okay. So let's proceed. So bringing a matter to court. Sorry, there you go. Again, the Children's Act as it is do to some extent speak to this, to say how do you bring a matter to court. The rules again is just amplifying that to make it clear, and then also to some extent clarify some of the things that's not clear. And for example, like the Form 2, because a lot of times I know some of the clerks of the court will say to you, no, this is the Form 2, you complete this, this is what you do. And I know I've been told by some colleagues that if you try to change the Form 2 or you want to add something, then they say, no, that you cannot do. You must use the Form 2. And I'm sure all of you have seen the Form 2. It's a small little block on the Form 2, and there's no way that you can put in all the information in that. So the rules are also trying to amplify that. So it still refers to the Form 2, but it says further that subject to the provisions, an application may be brought on a notice of motion, corresponding substantially with Form 3. If the nature of the action does not favour the use of the Form 2. I think typically to me, when you do an urgent application in the Children's Court, the Form 2 does not make requisition will be more appropriate for that kind of application. So it must be, it says that if you're going to use the Form 3, which is now your notice of motion, it must be accompanied by an affidavit of the application, the grounds upon which the application is based, the relief sought, and where available, all documents and reports relevant to the application must be. Designated social worker may attach a report instead of an affidavit. Going back to what we said, the purpose and objective of the rules was that to make it more say to if a father, a mother, grandfather, grandmother wants to bring an affidavit, what is it that you need to set out in the affidavit? I think as lawyers, some of this, if you do an affidavit, you must tell a story, you must address the reason for your application, you must make out a case for your application. But this rule just sets out more explicitly for anyone that is what must be an affidavit. And then interesting that if a social worker is bringing the application, they do a report. Again, just how to bring a matter to court. It tells you again what must be in that application. But this if you look at the information they require, it speaks very much to the Form 2 as it is now. It says the names, the preferred address, the particulars of the child. It just goes a bit further to say the name of the school or the preschool of the child, if available. It's not so; it's not necessary. And then the names and the residential postal work address of the other parent or caregivers must be also. So this is similar. This is very much the Form 2 as it is there at the moment. Again, it just says further what information must be in the application. Then important, if you look at F, it says there must be a statement as to whether the family advocate, social worker, psychologist, or other professional person or body is involved. So you must put that before the court. Again, I think it's something that does happen. Surely one would think that that information will be placed before court, but I think all of us have come across applications where you think, oh, okay, you read it and you think, oh, okay, well, there's important information missing, usually on purpose, because they want to hide that there has been a psychologist or a social worker involved in the matter prior to bringing the application. I think a lot of times, you know, where you get those applications are a bit of forum shopping, they would deliberately leave out the involvement of previous social workers or psychologists. Again, then if you look at G, again, that idea of you must tell the court, is there pending matters, is there previous orders, was it final, was it interim, that relates to this specific matter. Then if there was existing court orders, what is the information and the circumstances to put the court in the best possible position to decide the matter before court. Again, one must think that the rules must be read with the Act and with the regulations. So this is just to amplify what the Act already says and the regulations, to say the presiding officer may make any other order provided for in the Act. So there's already a section in the Act that says what orders can the court make. That's 46 of the Act says that the court, what orders can be provided, that when application made is ex parte, the provisions of Rule 7 must be complied with. So you must just then, those are then the rules of around notification and so on. Order the investigation of the application. Again, similar what they do now, they will issue a Form 9 to call upon somebody to appear before court, grant such order as it deems necessary to safeguard and act in the best interest of the child. So typically one must think that here would be maybe where they look at the application and they might give an interim order to safeguard, some kind of order to safeguard the best interest of the child. So we spoke the last time about specific time periods, and I think the lady from Tanin said specifically they were, you know, this whole thing of when and how it must be heard. So the rule says specifically here, the court must allocate a date for the preliminary hearing of the application, which date must be within 20 days from the day the matter was referred to the presiding officer. And then the court must also direct if the child is to attend the hearing, taking into consideration the child's age, health, and personal circumstances. So again, this court must direct goes hand in hand then with the participation. So one would think here that if there's an application and if the court has to give effect to this whole idea of child participation, the court must then here say, well, the child is 12 or 13 or 10 or 9, clearly able to understand, so they must attend the first hearing of the matter and then give a date, and then that date, if you look at the rules, must be within 20 days from which the matter was referred to presiding officer. I think the last time we also spoke about if this is going to be always practical, take into consideration the roles of some of the bigger children's courts, like in Johannesburg, Pretoria, Cape Town, the bigger cities, where the diaries of the courts are usually full weeks in advance. So the 20 days, but that is what the rule says, and the administration of the court should surely take this rule into consideration to see how they deal with the roles. So we spoke about the ex parte application. So that what they said in terms of the court must give guidance and also be satisfied that, for example, should notice be given? Is there urgency? So must it be temporary nature? Who must appear before court? There must be a specific date. So again, the court must look at it and give directions as to how they must deal with the matter going forward if it's an ex parte application. Services of process and notices. Again, similarly, the rules, I think there's nothing here that is strange. If you look at the rules of the High Court, of the Regional Court, of the Magistrate Court, where it deals with services of processes and notices, again, the rules are there to guide you as to how notices must be served, when it must be served. So this is similar to that. So it says that service of processes and notices can be effected personally by a sheriff, a clerk, a peace officer, or a person authorized by the court. A person authorized by the court might be a social worker, or so there is no description about who can this person be, but I can think that here a person authorized by the court might be the social worker. Submitted to a party by registered post. Yeah, I don't know if the court will necessarily pick this option, because in currently in terms of our postal service and registered post, it's not the most reliable. Served or submitted in any other matter as directed by the court, or served on the chosen facsimile or email address of the other party. I think nowadays one would, if one goes back to C, I think there has been in the past case law from the High Court that has authorized service of pleadings and notices by way of Facebook, by way of maybe WhatsApp, and especially I think where addresses are sometimes nowadays a big secret. Nobody wants to disclose where they stay, but it will be amazing how much conversation takes place via WhatsApp or an email. So the court can maybe from your side, if you bring such an application and you will be struggling by a way of service, to say, well, the rule says that the court can direct a manner of service. So maybe that is something that you can consider, to say that lets the papers or the notice be served by way of WhatsApp. And WhatsApp is so easy in terms of proof of service. You can see the person who's read the WhatsApp, you can export the chat, and that can also be presented to court as proof of service. Must be served. So it says that unless directed against the guardian, every application must be served on the guardian and caregiver of the child. So comment and motivation are requested. So again, that unless it is the guardian, every application must be served on the guardian and the caregiver of the child. So that, and a caregiver, if you look at the Act, it's something a bit more wider than a parent. So a caregiver, if the child is living with a granny, an aunt, stepmother, stepfather, that can be a caregiver, and then the application must be served on them. So so the rules also say that when the court has to have a preliminary hearing, there's certain things that the court must ascertain during that preliminary hearing. So the court must gather information and make such order as the court deems necessary to investigate the application. Then they must determine who has to be present, deal with interim application and orders, give such orders, instructions or directions to the clerk, the social worker or other professional as the court deems necessary, and case manage the application in order that it be finalized speedily. So you'll see all of this links into each other to say that this first preliminary hearing of the matter, the court must do, even at that stage, the case management would start to make sure that this matter is finalized speedily. So what would be necessary, even at this early stage, if one looks at the hearing or at the application, to make sure that the application is dealt with speedily. I think hopefully, going back to our colleague and Tanine, if one have these rules, you can say, try to, at this initial hearing, if you are present, to say, okay, but, you know, Your Worship, this and this and this is going to be necessary for this matter to be finalized. So even at that first stage, start the case management, make sure the necessary instructions and directions go out. I know a lot of the delays, and we spoke about it the last time, to say that, you know, the court can give an instruction to a social worker, but that social worker, despite the instruction, might not come to the party. But I think there already one should now say, well, if the purpose of the preliminary hearing is a case management, let's now I mean, if you work in a specific jurisdiction, you're familiar with the issues of that court, of that area, to say, even at this stage, Your Worship, can we not have a directive that if the social worker is not present at the next hearing, or say that we know this specific organization does not cooperate, so can we not someone now already have the social worker and the supervisor? So that idea of case management, making sure that everything goes smoothly. So in terms of then bringing the matter to court, the rules also again guide the court, and it says the court must consider these things and give direction in respect of that. So yes, I think it is very prescriptive. Sorry, I forgot to put my phone on silence. It's very prescriptive, but it might also be necessary in terms of that idea of case management, in sense of getting the matter finalized, getting it ripe, getting it up to a point. So the court must consider and give direction in respect of legal representation for the applicant, respondent, and the child. But I'm sure a lot of your presiding officers would in any way explain to a father, a mother, whoever is one of the parties, you're entitled to legal representation and so on. The need for interpreter, the need for intermediary, the need for a comfort person, investigation report by a social worker, submission of reports and affidavits. So I think, again, that thing already from the beginning, to like we sometimes would do in a matter by agreement, to say you submit your affidavit by then, you must do it by then, you must do it by then. So again, this gives us the scope of, if the rules in terms of the children's court, also to agree to that and make sure that the timelines are determined from the beginning. Attendance of any other person, to give directions on that. Exchange of reports and documents. Now, yeah, I know that I think, yeah, it's a good opportunity that we would then, as a legal representative, ask that social work, that we ask direction from the court about the social workers report. Because I'm sure if I ask a lot of you, you will say one of the biggest frustrations in terms of conducting your client's case is this thing of not getting the reports prior to a hearing. The social worker report, I'm sure all of you've heard this before, that the social worker's report belongs to the court, and if you want a copy, go and get it from court. So I would suggest that in terms of the rules, you maybe at the first hearing or the second hearing say to the court, look, this matter is now part of your duties is a bit of case management. And we want from the beginning, we want a directive from you on how are we going to receive the reports and if we're going to receive the report. So that at the beginning, they can give it, the court can give a directive to the social worker to say, hey, ma'am, sir, remember, I'm here now making a note that report should be given. I mean, this morning I walked into the children's court and the presiding officer said, oh no, this case, she's happy with the recommendation and she wants to finalize it in terms of paragraph so and so of the report. So I said to her, oh, I don't know. The report wasn't given to me, so I don't know. And then afterwards she gave me the reports. So, I mean, luckily it wasn't a big fight, or, I mean, there was no controversial recommendations, but I mean, that's like, give me the report after the matter is finalized. That helps a lot. I mean, the report must be available. And a lot of times the delay comes because you get the report at the morning and then you need to consult with your client. And then the client gives you a whole 2-page, 3-page of instructions or say to you this or that. And then you have to ask for postponements to deal with the report that you received the morning. So then the court can also consider if there must be maybe family group conferences or a lay forum, and you will see that in terms of the Act. Those are the types of resolutions or ways that the court can consider, whether maybe there's a question of law or fact that may be conveniently decided separately, or any other matter relating to the conduct of the matter. So hopefully, I think with regards to this, there might be some way we can streamline the proceedings in the Children's Court also. So again, I just want to pause here to see maybe if there's, from your side, any questions or comments. So let me just go to the chat. Okay, I see the audio is, the Form 2 is the Form 2. If I can answer you, Ms. Liebenberg. I don't know why the volume is so bad. Let me see from my side if I can maybe make it louder. I don't know if that will help. So the Form 2 is the Form 2 as we know it now, and the Form 3 is then the new one that they say that is the notice of motion, but your notice of motion must be similar to Form 3. When you see, when I will upload the PDF to the web page, you will see the Form 2, but that's the difference between the two forms. I hope the sound is, or the audio is now a bit better. Okay, sorry about that. I think it's sometimes all the issues. Okay, any other questions or comments? Okay, we don't have a lot of slides left. I'm sure all of you are also tired and want to go and have some dinner or carry on with some other more exciting things. So chapter 5 deals with parental rights responsibility agreement and parenting plans. So just to reiterate the main difference between the two, parental rights responsibility agreement, if you look at the Act, it is between the holder of parental responsibilities and right in any other third party, be it a father, a grandparent, an aunt, an interested party. That's a parental rights responsibility agreement. The parenting plan is exactly what it says. It's a plan between two parents. So a parenting plan is always between the parents of that child or children. So the parental rights responsibility agreement, in terms of the rules, it must be in writing. Again, it refers to the Form 11, which you will find in the proposed rules that I'll upload. It must pertain particulars with regards to care, the contact, the financial responsibilities, any incidental matters related to the upbringing of the child, which I'm thinking of an example, say, because remember, this is an agreement between the holder of parental rights responsibility and a third party. So let's say it's a grandmother, and the grandmother is going to be responsible for the medical costs of the minor child. So that would be something that you were going to put in the agreement, because that is incidental to the upbringing of the child. But that is relevant to then the responsibilities of that person that is then a party to the agreement. There must be the registration of the agreement. where parental responsibilities and rights are to be exercised in substantially the same manner by the biological father or any other person having interest in the care of the child, such parental must be conducted for each child. So you can't have a sort of a one agreement for more than one child. So just have a look if it's a person with regards to one child, is there more than one child, but that has different people involved in that child's life, that you then have an agreement for each of the child if the facts of the agreement is not the same. The applicant for the registration. So this is where you file it with the agreement with the family advocate or the court. So you will see again, it talks about forms that must be submitted with the agreement when you submit it to the family advocate or the court. When a family advocate is required to satisfy himself or herself that the agreement is in the best interest, this must be stated in a form. So again, a lot of these things are very formalistic, what must go with the agreement when you submit it to the family advocate or when you submit it to the court. It says also specifically that the child's views and wishes must be given consideration, bearing in mind the age of the child, the stage of development. The child must be informed of the contents by the family advocate, the court, or the social worker, the social service professional, psychologist, or the child's representative when made an order of court. So this is more, it goes a bit further than where we are now, because it places a duty on any of those people, the family advocate, the court, the social worker, the social service professional, psychologist, or the child's legal rep, to inform the child of the contents of the agreement. Again, this idea of does it, how it's going to happen. Again, I think a lot of you guys have drafted settlement agreements where you refer to the Children's Act to say, no, the child has been informed, because no family advocate will in any way endorse an agreement without that paragraph that says the child has been informed if the child is old enough. But I'm sure if everybody will be honest, that happens in less than, I would say, 2% of cases that the child is actually informed of the contents. But everybody says so. But the rules now says that it must. The child must be informed. So again, one step further in terms of child participation, it says that if a child is informed of the agreement and the child is not in agreement, that should be recorded on the agreement, and it must be referred for a mediation or assistance by the family advocate or the social worker. So the rule takes again this idea of child participation, of considering a view, considering the wishes, takes a little bit further to say that it must be recorded if the child is not in agreement. So parenting plans, you'll find again there's a whole terms of a lot of formalistic the requirements that you must meet in terms of a parenting plan. So a parenting plan can be prepared with the assistance of a family advocate, a social worker, a psychologist. After mediation, it must be a parenting plan must be can be entered into. I think a lot of the problems with parenting plans come in with this, because it says it must be prepared by any of those people and it must follow a mediation. Now, I'm of the opinion that the Children's Act gives us a form, and the rules give us a form with regards to a parenting plan, and all these people listed, except the family advocate, costs money. So what if two people say, well, we want to enter a parenting plan, and they don't comply necessarily with, and there's not a mediation, they just enter into a parenting plan. Is it not a valid parenting plan? And my answer would be no. It's just because it wasn't a mediation or it wasn't done with the assistance of a family advocate or social worker, it's still an agreement. It's still two people that have applied their minds and they've entered into an agreement. That parenting plan surely is enforceable, and it's a plan, it's an agreement between the parents. Again, this idea that a child participation is reinforced to say a child must be consulted during development of a parenting plan and given an opportunity to express his or her view. If I know from experience that a lot of times if a parenting plan is done through a social worker or a family advocate, then they would in any way do what we call a voice of the child interview to get the views of the child as part of the parenting plan. Then also similar that they must be informed by any of those people as listed here of what is the content. So yes, they participate, but then afterwards they must be informed of the contents of the parenting plan. So the rules also talk to the child in need of care. I just want to stop here to see in terms of some questions. So I see there's a question to say if it's possible to send us an example of a parenting plan that you have used. I will upload that. Let me just make a, sorry, I just want to get my book so I can just make a note, because I will forget if I don't make a note of it. Just to say here, I'll upload a few examples. And then Dale says, if parties are assisted by attorneys or experience, is that not a mediation to a certain degree? Yeah, Dale, I don't see why not. And I think again, I come back to, if you look at the forms, maybe I must say this first, if you look at the forms to the act and to the rules, you'll see there's this little sections in the parenting plan that must be completed by the mediator. So I don't see why, if you guys, if you as an attorney assisted with that and you fill in that little form and then you present it to court, why it shouldn't be accepted. The mediation part is more enforced by family advocates than by the courts, in my experience. It's usually if you want to just register your parenting plan or your parental rights responsibility agreement, that they are very specific about that certificate by the mediator. It's not usually enforced by the courts, but I know the family advocates are pedantic about it, and they won't register a parenting plan if that specific section is not completed and it's not mediated as we understand an appointed mediator. So if that is going to be making it just an order of court, might be the better way of doing it, because the children's court, as from my experience, will just ask for confirmation in terms of an affidavit, maybe by both parents, to confirm that this is their signature and they agree to it freely and without any undue influence. So I hope that answers your question. I can, during our next workshop, I can talk to you about the voice of the child. We can do that. And then Ms. Liebenberg, yeah, I can also give you an example of a parental rights responsibility agreement. Please note that the examples that I will be uploading refers to children and parties, so I might just be blacking out certain parts, so don't be surprised when I upload a document and there's parts of it blacked out. So just in case, we have a whole protection of personal information acts that's going around, so I don't want to contravene that those provisions of the act. Any other questions? Okay, so let's go back to talk about the child in need of care. So I think this is the section where last time we spoke about specific time periods and we must do what, when, how. This rules in chapter 6 talks specifically about that, how the social workers must conduct the investigation, when they must do what. So the rules also will not only help them, but I think will also help the practitioners that are trying to enforce the rules. Sorry, I just want to take as I was saying at the beginning, my chest cold is going to maybe interfere, so just give me a moment. So when somebody alleges that a child is in need of care, an application can be made to court using a Form 2 for an order to place the child in a temporary safe care, supported by an affidavit as to the facts. But then, if you look at the rules, there's two scenarios here that the rules contemplate. So the one would be if an interested party, if a parent believes a child is in need of care and protection, and they then complete the Form 2, and then the rule says you must attach an affidavit. But the court says that if an application for care and protection is brought by a designated social worker, it shall not be necessary to complete and file a Form 2. So typically that will be the Form 36. So they wouldn't do a Form 2, they will do the Form 36. So it says the court must then look at the application and ask for further additional evidence if they deem fit, including oral evidence or evidence by affidavit, which will then form part of the proceedings. Again, I think typically this doesn't say anything if it's a parent or a person bringing the application or the social worker, but the court can then ask for further evidence either by way of affidavit or oral evidence. So I think typically that would be a social worker maybe coming to court, that the court will swear the social worker in and ask questions under oath. So it says that a parent, a guardian, a caregiver, or a child may file opposing affidavits, adduce evidence, call witnesses, question witnesses with permission of the presiding officers as an address the court. So I think it's just a confirmation that inquiry into care and protection is similar to any other civil litigation. Just confirmation of those rights that as a parent, a caregiver, or then even a child may file affidavits or adduce evidence. I think sometimes it sounds, if you look at it and you want to go like, duh, really? But again, I'm sure all of you, if we had an opportunity, would tell me that in your children's court, if somebody tries to file affidavits in a care and protection matter or call witnesses, there's a lot of presiding officers that will frown upon it, maybe stop it. So again, the rules are just making it easier to protect everyone's right, including the child, in terms of how proceedings must be taken care of. So going back to earlier what we said in application and ex parte application, again, this is similar to your civil litigation urgent applications. When ex parte application is brought, the court may consider the application without notifying the parent, guardian, caregiver, or child, or order that the notice be given. So that whole idea of being directive, giving directions from the beginning. When they give that directions, the court must have regard to the best interest, which again is a bit common sense, because it says that all proceedings or the best interest of the child is paramount in terms of all proceedings. So the court says the rule says that if the presiding officer is satisfied that the child is in need of care and protection, then the court can make an order that there must be investigation and make additional orders in terms of Section 50 Act, and the court can also then issue interim orders in terms of after just hearing the ex parte application. I think all of us, so in terms of Section 50 deals with investigation, so the court can then make orders in terms of how the investigation must be dealt with. Yeah, I think we all, especially if it's maybe not a social worker and a parent or a caregiver or granny or aunt that brings this ex parte application, one feels that the scope for abuse is there. And you'll find that some courts, a colleague of mine phoned me this morning to say that on a Monday morning following a visit to a parent, they were presented with an interim order, and the Children's Court has removed the child from the care of the one parent, despite domestic violence orders. But now what they did, a bit of forum shopping, in that the child stays in Bella Bella, and they went to the court in Rustenburg, where the child is actually not residing. But so, don't tell the court about all the domestic violence applications in Bella Bella, but just go to the Children's Court and get an interim order. So one would hope that the courts are, especially if it's brought by a parent, that they would carefully consider just giving interim orders, and they would rather just order investigations for the social work, and again give firm directions as to when and how things must happen. That whole idea of case management and being strict. The rule also just giving the court more guidance as to how to do it and what to do it, and also for us as practitioners to know what we can expect from the court when matters are heard, that the court must review whether it was necessary to remove and place the child. So this would be more where you have the social worker or the police that has removed the child without court orders, and then they come to court and say, please confirm the removal, so that they must make sure that removal was necessary, and that there maybe, should there not be alternative measures and not just remove the child. And the court must ensure that the child, the parent, the guardian, or the caregiver is appropriately informed of the nature of the proceedings. That duty of the court to make sure everybody understands what it's about. If the child was removed by court order, the court must consider any evidence previously received when they removed the child. So the court may, in addition, also consider further affidavits, rely on written reports, postpone the matter for shorter periods of time to call for further evidence or for the purpose of giving notice. So again, that whole idea of a bit of a case management, not strictly just doing this or this or this, but applying the mind and say, look, yes, I can postpone it for 90 days, but clearly there's something we need to sort here, so let's do it a shorter postponement or somebody. So that idea of case management, I think that when the rules are implemented or published, that as practitioners, we will have to maybe also just educate the courts a bit on how they can case manage the matters better. Oh, sorry, I see this slide. Let me just end the slideshow here. I don't know what happened to. There you go. That picture didn't go where it's supposed to go. Again, in terms of chapter 6, a designator or a social worker or a police officer may remove a child or place a child in temporary safe care without a court order. But if you go back to the chapter in terms of the course, it already sets out how children can be removed with a court or without a court order, with a social worker, by a police official. So again, this rule just speaks a bit more to the provisions of the Act and the regulations. So it doesn't really add something, it just amplifies what's already there. So the Rule 31 of Chapter 6 talks to when the court makes these provisions for where the time period for where a child is in temporary safe care, where a child is not in temporary safe care. So Rule 31, and sorry, I don't have my rules right in front of me for the moment, but speaks to more the time periods that the court can lay down in terms of these investigations. So just in terms of the general rules that's in chapter 9, I just want to go back. I'll make a note to say that Rule 31, we will at the next webinar just have a look further into Rule 31, because the time periods there is quite extensive. So I think that's also why I didn't bring it into this presentation, because it's quite extensive, those time periods, that we can have a look at it more specifically. So an application to make a settlement agreement and order of court must be made in terms of Rule 6 and be served upon the respondent unless it originates from existing court proceedings. Then if you apply for the settlement to be made, a court order contains the following: the settlement agreement, an affidavit by parties confirming the agreement and the signatures to the agreement, and the statement that there's been compliance with provision 6.5 of the Act. And 6.5 of the Act is what I referred earlier on, that is where people say that the child has been informed and matter about the actions or the decisions, in which I say that I doubt that if it really happens, maybe there is a small percentage of matters that it does happen. Then if a parties agree that a settlement agreement can be made on order of court, it must also, that statement must be in the agreement that they agreed that it be made an court order. Again, I think something like, for example, B is something that the courts already apply, that if they usually, well, in courts that I appear, the presiding officer will say, well, the parties can be excused from the next appearance for the order to be made, but there must be affidavits by the parties confirming that the agreement is the agreement and that the signatures are their signatures. The chapter 10 that deals with access to the records of the proceedings. Again, I think in practice something that is problematic. So the rule also just tries to make that process of access and who and why and how and who can and who cannot, make it a bit more streamlined. So there's maybe a bit less controversy about it. But again, going back, remember what we said in terms of the case management, that we don't have to now have these kind of extreme applications. You'll see have access to the records under office hours, under the supervision of the clerk, or so that if all the parties do proceedings, that you get directives from the court from the beginning as to access to the files. I think what is important, however, is that says that any other person that's not a party can apply, and they must give reasons, and then why they should be given access. So I think that's sensible, because information in the children's court file is sensitive. It contains a lot of details about the child, so one cannot have just anyone getting access to the file. But in regards to parties to the proceedings, it might be, if we go back to the previous rule that says that might get directions from the court from the beginning. Contempt. As I said, there is a chapter in the online course that deals with contempt, something that is not always easily enforced. But this also, the rules deals with not only the contempt in terms of a party to, or if there's an order, but this is who's during the sitting of the court. And I think all of you can tell me stories of proceedings where you have been involved and then a parent or somebody involved in the matter just becomes unruly. So this rule says specifically that any person who during the sitting of the court willfully insults an officer or willfully hinders or obstructs an officer, willfully interrupts the proceeding or otherwise misbehave, or does anything calculated improperly influence the court, may be by order of the court be removed, and then the proceedings can proceed in the absence of that person. Yeah, in one of my matters, I had the attorney that was acting for the grandparents. All of a sudden, the children were testifying, starting to make a video of the children testifying without anyone's permission, without informing anyone. He was doing it behind my back, and luckily one of the other attorneys involved in the matter saw him starting making the video. And one would think that, is this not misbehaving? Is this not contravening of the rules, and can we ask him to be removed? But he's now representing a party which I doubt if the court will ask him to be removed, because that's going to directly influence the representation of the other party. Then the further deals here with then the proceedings, and that speaks more to the chapter sorry, the chapter of the in the cause where somebody is in contempt of an order. Sorry. Again, it's there in the Act. It's not enforced by the court. And just in this week, a colleague of mine the mother was willfully disobeying the order, and the court didn't find her in contempt, but then rather adjusted the existing order and then said, okay, but if you don't now obey this order, then we're going to find you in contempt. So this the whole time, yes, all the proceedings are there, all the rules are there, but it's so difficult to find somebody in contempt of a court order. So it says that any person who deliberately, willfully, and mala fide disobeys an order may be held in contempt. Sorry, an application for committal must be brought in the form in terms of Form 3. So that will be your notice of motion, accompanied by an affidavit and a certified copy of the court order. Now, I know in some magistrate courts and some children's court, the files and the record keeping is a bit problematic. I know a colleague of mine is struggling to find a court order to bring a contempt application. So that can also sometimes be a hindrance to a contempt application. And the applicant must, beyond reasonable doubt, prove that an order has been given, that the respondent knows about the order. Then there's the burden on the respondent to advance evidence that the non-compliance of the order was not willful and mala fide. If the respondent fails to advance evidence that establishes reasonable doubt, the contempt will have been established beyond a reasonable doubt. So if an application is lodged, it says lodged, the clerk must immediately submit the application and the affidavit to the presiding officer. Okay. So again, we will make the slides available. Grace, I will upload it as well as the PDF format of the rules, so you can also see all the forms that is part of the proceedings, or part of the rules. Okay, any questions? I see Dale is typing something. Somebody else that wants to maybe ask a question. Okay, so Dale's question is contempt where there is parental alienation. My client's husband does not allow her to collect the child on contact time, stating the child that does not want to see his mum. The child is only 8 years old. Is this contempt or is really the voice of the child? So I think the question, if it comes to contempt proceedings, about a court order. So is there a court order that says that the child must have contact? And if there is, then you know, a good starting point might be bringing in a contempt application. Remember, you must say there is an order and it's not being complied with. And then it's for the other person to come and say, it's not willful or not male fide. So it might be a good starting point to have a look at this voice of the child, because if one of the defense or the answer to the contempt is that the child says so, then the court must appoint a legal representative for the child, so the child can be separately heard, and to see, is it really the child's voice, because that's easy to determine, or is it just a mother hiding behind the child? But for me, the correct starting point will be contempt proceedings. Okay. Yeah, Dale, and I'm sure all of you that are here can tell me stories that contempt proceedings is really something the courts are struggling to enforce, or to actually find somebody in contempt. And I printed out the judgment of the Concord on Mr. Zuma and committing him to prison for contempt. Clearly the Concord thought that non-compliance with orders are serious. So I don't know why the children's courts have this think of, oh no, poor parent, but let's give them a second, third, fourth, fifth chance before we find them in contempt. Because it will only take one or two courts of actually finding parents in contempt. The story will spread, and you'll find, I think, less people that are trying to duck and dive court orders. Okay, any other questions? There's apologies for my voice becoming softer and softer. Okay. Okay, guys, then thank you very much. It's already 8 o'clock, so it's been a long day, I'm sure, for all of you. So please enjoy the rest of your evening. Okay, I see there's some, I don't know if there's a question coming or just okay, good night. Okay, but you must enjoy and good night, and then we will see each other for the last one. So I will have a look at the last webinar. I will have a look at the voice of the child, and then also I'll upload the examples as you've requested. So thank you very much.